I'm Josh Normanton. I'm a barrister at Five Paper Buildings, obviously. This is going to be a short talk about, as Andrew said, the powers that law enforcement agencies have or are about to have to get hold of electronic data from other jurisdictions. And from the defence perspective, which is perhaps slightly a little more interesting, what are the challenges to the exercise of those powers? The focus of the talk is on the Crime Overseas Protection Orders Act. For this webinar, a bit of a mouthful, the 2019 Act. And I'm going to begin by outlining some pre-existing powers. It will be clear to you that the powers available to the state right now are pretty fragmented and have some fundamental limitations. And seems obvious that the 2019 Act is in place to address that. But while the 2019 Act is in law, it's had royal assent, it's in fact not yet possible to make an order under it. Because what you also need is a bilateral agreement in place with the jurisdiction to facilitate the order made under the Act. But newsflash, there is an agreement in place with the United States, which is likely to come into law very soon, given a statutory time limit applicable to the United States Congress, which is why it seems important to review this area of law now in a bit of detail. Because for some law enforcement agencies, when all of this falls into place, all their Christmases may well have come at once. And there may be a significant impact on many different types of cases and clients relevant to the experience of all of those listening to this webinar. So I'm going to set out the background briefly, so you can see the Act was considered necessary, then have a look under the bonnet of the statute and the US agreement, start having a think about how these orders could be challenged. This webinar does focus on electronic data that has a specific definition under section 3.2 of the Act. The rather elegant electronic data means data stored electronically, but on a practical level, it can cover all manner of information, fraud investigations, banking data, company documents, in terrorism cases and even confiscation cases, Facebook, other social media information, and also data from file sharing or image board websites, which are often key to disrupting paedophile networks. So turning to my second slide, just want to have a look at some of the pre-existing powers. So you've got a client right now with some electronic data abroad that the authorities want to get their hands on. How can they set about obtaining it? What are their powers at the moment? Let's assume it's password protected banking data held on a foreign server in the United States. Well, the first tried and tested tool in the armory is section 20 of PACE. Section 20 allows a constable, as part of his pre-existing powers of seizure, to seize electronic files, either stored on a device on a premises or accessible from the premises. So that might include material stored on the cloud or cloud software, which is accessible from a computer terminal. There's a few obvious limitations to section 20. You can't obtain information which is deleted from a computer. Equally, you can't obtain information on a foreign server if there's no accessible pathway to that server, for example, if that pathway has been deleted. And you can't obtain information which is password protected or encrypted as banking data usually is, assuming that you can't get hold of the password or isn't being handed over. Section 20, of course, only applicable to companies as well, with premises in the UK which can be searched. So much for warrants. Turning then to the SFO's powers under section 2.3 of the Criminal Justice Act 1987. So it's still on the same slide, please, Andrew. So the pre-existing powers slide. Subsection 2.3 means that the SFO director can issue notices which require persons, either those under investigation or others, to produce documents relevant to investigations. If one looks at the section, I'm not going to read it out, you'll be glad to hear, there's no reference at all to extraterritorial application of that power within the section. And it's not clear on the face of it that it could apply so as to obtain electronic data from overseas. You can't mention section 2 though without also mentioning the judgment of the divisional court in KBR and SFO, in which a US parent company, KBR Incorporated, went to the divisional court to try and quash a section 2 notice requirement to produce documents relating to one of its UK subsidiaries. And that related altogether to an investigation into corrupt payments. Now, depending how you look at it, KBR and SFO involves the divisional court either extending the scope of the subsection, so it had some extraterritorial effect, or merely confirming the existence of that unmentioned power. In KBR, Lord Justice Gross concluded the section did have an element of extraterritorial application, because if not, a UK company would be in a position to forestall a serious fraud investigation by simply transferring documents abroad. If you're interested, you can go to paragraph 66 to 69 of that judgment to see the full set of the reasons why it was decided that the section was of at least some extraterritorial application. One of the factors was that the SFO was there to combat top-end, well-heeled and well-lawyered crime, which usually has an international dimension. The takeaways from section 2.3 are that it extends to foreign companies in respect of documents held abroad, only where there was a sufficient connection between the foreign company and the jurisdiction. Well, what does that mean? In KBR, the fact that the high-ranking employees at KBR Incorporated, the US firm, had approved the payments in the case, and also that the KBR Incorporated's corporate officer had been based in the UK office for a period of time, well, that was considered sufficient. But being a parent company in and of itself is not. So applying that in terms of the scope of the power, we've got a pretty limited pool of companies, and it's quite case specific. And of course, it's only a power afforded to the director of the SFO. It's not a process which City of London Police, for example, can easily embark upon. There are also other issues that I'm not going to go into with provision of notices outside the jurisdiction and enforceability in those circumstances. The also not insignificant issue is that KBR Incorporated was granted leave to appeal by the Supreme Court in April last year, an appeal which was due to be heard in March, but of course coronavirus has stopped that. So much for the SFO's powers. We then come on to requests for mutual legal assistance. Well, this is the mechanism all police forces and government agencies have to turn to eventually to obtain the information they want from overseas. If anyone listening has been in a case where there's been a request for a MLA, you will know that it could stand for massively long and arduous. After a police officer makes an MLA request, the request passes through an almost infinite number of nameless bureaucrats and undergoes various vaguely painful sounding treatments, minimisation, to shape what you're likely to receive. How long is that process? Well, there's no fixed period of time. The explanatory memorandum to a new US-UK agreement I'm going to come on to states that the total time for the process of an MLA request is typically a year, but can be years. Anything that streamlines and shortens that process is obviously going to be number one on the Christmas list of investigative agencies. So much for MLAs. Where does that leave us in terms of electronic data? Well, in all cases that aren't dealt with by the SFO, if an officer can't access the data from here, then the authorities are asking for an MLA and should settle down for the long haul. But with the SFO, one can request a company with a sufficient connection to the UK to produce documents held overseas. But of course, that doesn't give you access to the big data sources held by the US companies necessarily, and the SFO often fall back on MLAs. So in an effort to deal with the obvious lacuna, if we could turn to the next slide, we've then got the 2019 Act. So the purpose of the Act is to grant law enforcement agencies and prosecuting authorities the power to apply for and obtain electronic data directly from service providers for the purposes of criminal investigations and prosecutions. It creates a standalone legal regime and potentially quite a powerful one. Service providers are those who create, process, communicate or store electronic data, quite a wide statutory definition. Have in mind your Googles and your Facebooks and things of that nature. At first blush, what does it do that's very different from an MLA? It cuts out the middleman completely. Doesn't require the kind of involvement of a state operator in the country where the electronic data is situated. Effectively, someone in the Home Office is going to send this directly to Google or Facebook and they're going to have to provide the information. It got royal assent on the 12th of February 2019. It's over a year old, but at the moment it's a bit of a white elephant because it can't be used. Why not? Well, perhaps unsurprisingly, there needs to be some kind of bilateral agreement in place before a country will allow its companies to be ordered to hand over their electronic data. Section 4.2 of the Act provides that an order can only be granted in respect of information held by a person who is based in or operates in country with which the UK has made a designated international cooperation arrangement. I'm just going to call those arrangements from now on. I'll turn to one of those shortly, in fact the only one, which was the US. But I should also note that the scope of what you can actually obtain under the Act is actually pretty wide. You can potentially obtain data in many more jurisdictions than simply those with which we have an arrangement, so long as the person in control of the data is in such a jurisdiction. So that arises from section 6.4a, because the requirement to produce data under that is regardless of where the data is stored. So if the order is against Microsoft, the requested data is held in Ireland, then Microsoft will nevertheless be obliged to provide the data. Those are the overarching points in respect of the Act. Touched on some of it, but I wonder if we could look briefly at what the application process involves. It can apply to obtain electronic data, anything other than LPP material and confidential personal records. We read medical records, but look at section 3 for the specifics on that. Section 4 contains 7 relevant criteria which must be satisfied for an order to be made. Crown Court judge has to consider it. He has to be satisfied that there is an arrangement in place with the relevant country where the service provider is. He has to be satisfied that an indictable offence has been committed or proceedings have been instituted, or such an offence is being investigated, or the order is sought for the purpose of a terrorist investigation. Number 3, the person against whom the order is sought obviously has to be in control of the data. The remaining sections, so those from 4.5 to 4.7, require more of an exercise of judgment, and we will come back to these. Section 4.5 requires that all or part of the electronic data described must be likely be of substantial value to the proceedings of investigation, so something of considerable importance, something that's going to take things further. So subsection 4.6 requires that the electronic data must likely be relevant evidence. And the Act helps us elsewhere by subsection 4.11 by saying, well, relevant evidence means something which is admissible in the proceedings. And then there's a public interest test under section 4.7. Is it in the public interest for all or part of the data to be produced or accessed, having regard to 2 things: the likely benefit to an investigation, and second, the circumstances under which the person against whom the order is sought has possession or control of any of the data. We'll just come back and look at those last 3 shortly when we think about challenging. Anyone making an application or challenging or seeking to revoke an order will also need to consider any further restrictions arising out of the relevant international agreement. We've only got one agreement we need to be concerned about so far. I wonder if we could turn to the next slide. So this is the US-UK bilateral data access agreement. So it was signed on the 3rd of October in Washington by Priti Patel and William Barr, the United States Attorney General. He's in the news a lot. Gives effect not only to our Act, but also something called the US Cloud Act from 2018. But the agreement with the US is of particular value really to the UK. It's a negotiation which the UK seems to have won out significantly due to the volume of information which is held in the US, in particular by Silicon Valley companies. It's logical, in my view, that traffic will be largely one way, passing from the US to the UK, because we just don't have the kind of big tech firms holding the information that the US has. And more than merely giving effect to the powers under the Act, it carries other benefits, this agreement, because it means that the UK overcomes an obstacle it traditionally faced in getting information from service providers, communication service providers in the US. And that obstacle was a US statute called the Stored Communications Act, which meant that in effect communication service providers couldn't provide material to foreign powers. Well, we've overcome that with this new agreement. I will note, I'm obviously referring to it in the course of this talk, that the agreement isn't just yet legally operative. It needs parliamentary ratification, but I anticipate that won't be too difficult in the current climate, subject of course to the coronavirus. And in America, the agreement will become law 180 days from the date the Attorney General provided the executive agreement to Congress, and that was done some time ago, shortly after signing it. And so, providing the US Congress don't issue a joint resolution of disapproval, it's going to come into force, and there's no indication they're going to do that yet. So as matters stand, assume it is coming into force and fairly soon. The arrangement, the agreement contains other matters that need to be kept in mind in both applying for and challenging an order. Requests under the agreement can only be made for certain types of data, and I've set it out there. It is fairly wide, but it's specific to that. Information can only be obtained about serious crimes, and those are crimes that can be punished by at least 3 years imprisonment. Any requests must be made on the basis of articulated and credible facts. There are also specific arrangements which reflect the relationship between the UK and the US. The US can't use the agreement to obtain information about persons based in the UK, and the UK can't use it to obtain information about US citizens. There's also a provision reflecting well-known sensitivities of the respective companies. The US law enforcement has to obtain permission from the UK if they're going to use this material in death penalty cases, and conversely, the UK has to obtain permission if it's going to use the material in cases concerning US freedom of speech. So keeping the lengthy procedure for an MLA in mind, the procedure for obtaining data with this kind of order, given the bilateral agreement, is almost delightfully easy. The process involves obtaining a court order, sending it off to the Home Office. The Home Office then transmits it directly to the US service provider, and under Section 5.5 of the Act, the time within which the order must be met is 7 days. So we've gone from years to 7 days. And if we could then go to the next slide. So challenging orders, I've done a helpful little table to tell you who can challenge and in what way. There are really 3 routes onto the battlefield. Clients who are not communication service providers will only be able to follow one of them. First, on the basis of the Act itself, the 2019 Act, well, everyone can avail themselves of the power to seek to revoke an order under the Act. And Section 7 of the Act provides, in addition to the appropriate officer who applied for the order, any person affected by the order may apply to either vary it or revoke it, which includes, in my humble view, a person whose electronic data is the subject of the order. An application to revoke will want to focus on those criteria which really matters a judgment set out in Section 4. And as I said, those matters which were set out in subsection 4.5 to 7. So really you're looking at, under Section 4.5, is it of substantial value? It may be difficult for law enforcement agencies to demonstrate the substantial value test. It really will depend on the nature of their intelligence. I think at the early stages, people begin applying for these orders. We really need to be wise to fishing expeditions and scrutinise the basis for orders as they go on. Then the relevant evidence test under Section 4.6, really you're looking at the question of admissibility. And then there's the public interest test, which involves the judge also looking at the circumstances under which the communication service provider obtained the material. Under that, one might be looking at whether they obtain the material in a legitimate way or an illegitimate way, but also guarantees of confidentiality and things of that nature. And of course, it'll be fact specific. In addition to those subsections, you'll also want to have in mind the nature of the data sought. Does it fall into the category of LPP or medical material? Can that be shown? But also the time limit for service of an order. A police officer has 3 months to serve the order. Challenges are also available on the basis of bilateral agreement if your client is a service provider. That's certainly the case with the US bilateral agreement. You'll want to have in mind some of those additional restrictions and obligations under the agreement, in particular whether it falls within the definition of data, whether it's in relation to serious crime, and also consider the freedom of speech restrictions. One can imagine some quite interesting arguments coming out of that. Article 5 sets out the process for challenging within the agreement. The agreement does ensure that existing rights in domestic courts are preserved, so it may be open for a service provider to challenge an order in domestic courts, and that's something which certainly is worth considering. Clients may also want to know what the penalty for non-compliance is. Well, there's no explicit statement of the penalty for non-compliance with an order within the 2019 Act. In the agreement, it merely says any legal of effect of an order subject to the agreement derives solely from the law of the issuing party. taking that all down, what it really means is if you don't comply, you're probably looking at contempt of court and a fine, but also probably quite serious reputational damage. So there is the opportunity here, if justified, in particular if you're a service provider, to develop a pretty robust and comprehensive strategy to seek to challenge orders made. And it may be that in the early days, when these orders start being applied for, that is the strategy taken, given the risk of mission creep and ever widening applications. Because don't forget, as a police officer, you now have potential access to an almost limitless source of evidence. But if you're affected by the order because it's your data being sought, well, then you're stuck with challenging the order using the 2019 Act. But it seems there's a good bit of room for manoeuvre under those provisions. There's also the potential you may not find out about the order due to the inclusion of a non-disclosure requirement, in which case you may be challenging admissibility using some of the arguments that I've set out. Going then to the final slide. So that's the end of my short talk. What comes next is the bilateral agreement falls into place. Although, of course, if it's not in the USA, there's still a need to fall back on MLAs with other jurisdictions. You may expect a rise in various agreements being made over the course of time, certainly including with the EU, depending on how Brexit unfolds. Funnily enough, the EU is intending to agree something similar with the US at the moment. Thanks for listening. I'm obviously happy to provide any source materials or answer questions that come to mind over the next few days. Thank you.
I have a couple of questions that have come in, which I'm going to ask Josh now to return and join us to answer on his talk.
Okay, thanks, Andrew.
Josh, so the first question is this. Returning to your topic of obtaining information from overseas electronic service providers, the criteria under section 4, you mentioned that the judge has to be satisfied that the various criteria are met. Is that a test that's applied on the balance of probabilities or beyond reasonable doubt?
The answer is the balance of probabilities. I don't think there's anything in there which suggests it's beyond reasonable doubt, and certainly it would be very difficult, I think, to obtain orders at all if beyond reasonable doubt was the test, because it would be difficult for a judge to be sure that the evidence would be relevant, for example. So balance of probability.
Second of 3 questions, who can make an application? Is it limited to a constable, or are there other persons who are or can be authorised?
It's a good question, and it goes to the heart of why there's going to be a pretty significant impact when the agreement falls into place. Not only a constable, an HMRC officer, an SFO officer, accredited financial investigators, which is why I was referring to confiscation, counter-terrorism financial investigators, investigators appointed by the FCA to look at insider dealing and MAR and things of that nature, but also persons of descriptions specified in regulations by the Secretary of State. So it can be extended out. All of that is contained in section 2 to the Act.
Thank you very much. And finally, what remedies are there against a company or an individual in a foreign jurisdiction who fail or refuse to comply with the request under the Act?
So I think I touched on this towards the end of the talk. So Article 3.2, so there's nothing specific in the 2019 Act, that's the first point. So then you're looking at the agreements with the relevant international agreements. In Article 3.2 to the UK-US bilateral agreement, it says any legal effect of an order subject to this agreement derives solely from the law of the issuing party. I take that to mean it means that non-compliance, if UK is the issuing party, it is dealt with by the UK courts, and it'll be the same as any other non-compliance of an order. You're looking at contempt of court and a fine and things of that nature. So those are not quite remedies, but the penalties for not complying with the order. I hope that answers the question.
Just developing on that point, does that mean if a company is in the United States with no assets or involvement in the UK and they simply say, no, we're not complying, it may be that there's a limit to what can be done to enforce the order.
Yeah, I think that's right. The practical reality, though, is that communication service providers are going to have offices in the UK. There's going to be huge reputational damage of not complying with these orders. But I think the way in which it would be a strategic and logic way of dealing with it at an early stage would be to push back a little bit on applications for orders, so that you're not dealing constantly with fishing expeditions. Because if we think about the 7-day time limit in which to comply with an order, you have to collate all that material within 7 days. You're not obliged to provide LPP or medical material, so it may be that there are US laws which mean you have to take that out. That would be logical. So it may end up with really quite a large cottage industry in how to deal with these orders.
Thank you very much indeed. Thank you again to Josh, to Dennis and to Richard for their talks, but moreover, thank you everybody for joining us. Do stay safe, and we will be back next week at the same time, 3 p.m. next Thursday, when we'll have 2 talks, one from Jonathan Kaplan, Queen's Counsel, who will be talking about money laundering perspectives from the Far East, and the second from Aparna Rao, who will be talking about the case of Pell, a recent case in the High Court of Australia, and the potential implications of that judgment from the highest court in Australia for criminal appellants in England and Wales. Do take care. Thank you very much again for joining us. For now, goodbye.